It was a pleasure and an honor to work with him as he chaired committees in both the House and the Senate, and we passed a lot of good legislation in the process. Cal Anderson was a friend, an advocate, and a strong representative for this district. I'm delighted that this park is named after him, and it truly is one of my favorites.
Take a step back if you're comfortable there.
Yep.
Oh, step back. Sorry.
Back.
There you go.
So I can move out of the way for you.
That's what Michelle did. The backdrop. Yeah, there we go. Yeah.
Good morning, everyone. Thank you for coming. I'm pleased to be joined this morning by Bill Ayal, the chairman of the Cowlitz Tribe, and Director Casey Sixkiller, the director of the Washington State Department of Ecology. We are joined today by 14 other states across the country to announce a new lawsuit against the Trump administration filed here in the Western District of Washington for the threat to our environment posed by his illegal executive order declaring a national energy emergency when in fact no such emergency exists. But because of the president's order, federal agencies are now bypassing or weakening critical reviews under the Clean Water Act, the Endangered Species Act, and the Historic National Preservation Act. All of these actions cause direct harm to Washington state and our environment. And all of these actions are done to undermine state efforts to combat climate change and keep our communities safe. President Trump declared this national emergency at a time where U.S. energy production is in fact greater than it's ever been. And he says there's an emergency, but he has specifically excluded wind, solar, and battery projects from his executive order, despite the fact that those projects are some of the cheapest and cleanest energy sources today. And we know that the president's order is in part nonsense because he has already declared more emergencies than any president in U.S. history and issued more executive orders in the first 100 days than any president in history. This is not a serious or lawful effort by the president. It is all about eliminating competition and shackling America to dirty fossil fuels forever. But it won't lower prices, it won't increase our energy supply, and it won't make our country any safer. But we in Washington state and the other 14 states that have joined us will not let him try to maximize fossil fuel profits at the public's expense. I'd like to now turn to Chairman Ayal for some remarks as well.
Thank you, Dick. My name is Bill Ayal, chairman of the Cowlitz Tribe. And since time immemorial, the Cowlitz people have existed on the lower Columbia. We engage in permitting with the Corps on many aspects of the work of these proponents on the lower river. And we are there to advocate for our cultural and natural resources. The ecological function is critical for the preservation of our historic first foods. And we want to be there to facilitate the permitting on a proactive basis, but sometimes that's difficult if you only have 7 days or maybe 14 days, depending on the nature of the declared emergency. And so we just want to be assured that there is a factual basis for these emergencies. Looking at a project individually, if you did it carefully and planned it carefully, you would be able to minimize those impacts and get a facilitated permit. I just want to thank you for the time this morning.
Thank you, Mr. Chair.
Thank you, Mr. Attorney General. Thank you for taking this action today on behalf of the people of Washington State. Good morning. My name is Casey Sixkiller, and I'm the director of the Washington State Department of Ecology. As a parent, I think a lot about the kind of world we're leaving behind for future generations, for the opportunities they'll have, for the challenges they'll have as a result of the actions we take. For more than half a century, Washington State has been a leader in crafting environmental protections that reflect our shared values. create jobs, protect our natural resources, and more recently, to tackle the impacts of climate change. Today, we're talking about the latest effort by the state of Washington, led by our Attorney General, to stand up for our state's rights and for our environment. We're pushing back on efforts by the federal government to use its emergency powers to justify a reckless and unnecessary runaround laws and regulations to protect people and the environment, all to the benefit of big oil and gas corporations. Environmental protections exist for a reason. We've seen what happens when they don't. We've lived with the damage caused by their absence. When rivers caught fire, when air turned toxic and made kids sick, and after entire communities were left to deal with the aftermath of unchecked development and industrial activity. The federal administration's attempt to dodge critical environmental review under the guise of an energy emergency is one of many actions that ignore the hard-learned lessons of the past. Here in Washington state, we're still cleaning up the damage from a time when safeguards didn't exist. But unlike the federal administration, we've learned from those lessons. Emergency powers, when they exist in law, are intended to deal with actual emergencies, natural disasters, major supply disruptions, real threats to human lives. In other words, events that require immediate work to avoid unnecessary risks. There is no such emergency here. Declaring a national energy emergency when the United States is producing more oil and natural gas than ever before doesn't reflect reality. And declaring an emergency to speed up permitting processes by shortcutting environmental reviews is an abuse of authority. I've participated in these permitting processes from the federal side, both in Washington, D.C. and as the EPA regional administrator for the Pacific Northwest and Alaska. I've done it from the local government perspective at the city of Seattle and King County and now at the state. So I can tell you the system is working. My department reviews and approves over 100 federal permits every year. We have a streamlined process that keeps these permits moving, and we issue them within mandated timeframes, which is why you never hear about them. And yes, there are instances when more complex projects require more rigorous review to make sure we minimize risks to the environment while ensuring these important projects can proceed. By cutting corners, the administration risks throwing the entire permitting process in chaos for applicants and causing unnecessary harm to the environment. Every business and permit applicant I have ever worked with has prioritized regulatory clarity, certainty, and accountability. The fact is that the federal administration's actions will decrease regulatory certainty and create risk and potential liability for developers. The risk of environmental harm doesn't go away because federal agencies throw up their arms and say, whatever. State agencies, local governments, and tribes will do whatever is necessary to make sure the federal government's illegal actions don't harm our land, our waters, or the people of Washington state, including by filing this lawsuit. Environmental regulations aren't red tape. They're guardrails that protect our air, water, land, and keep people safe. As Governor Ferguson has repeatedly said, we're not going back. We're standing up for what we know is right. We're standing up for the law, and we're standing up for the people and places that call this place home. Thank you very much.
Thank you again, and happy to take any questions. Go ahead, John.
Got a couple.
You always do.
Yes, I'm wondering. Can I get you to elaborate on what the executive order actually does? And I'm asking this in the context, does it complete, say, like, for example, the Clean Water Act or something like that? Does it eliminate the entire act? Does it just eliminate regulations or rules that were later added under the act? Does it specifically get rid of reviews or public hearings? Asking for elaboration on one specific, if I wanted to build my, I'll use that, of course, Heaven Hills, wind farm. Yes, wind farm's not in this, but, if I wanted to, put a coal plant or put a oil plant or an oil line or something along the Columbia Gorge, what would be eliminated? What would the feds not be doing in addressing that?
Well, it's a complex answer, so let me try to simplify it a little bit for you. The order was actually issued by the president in January, and it directed a number of departments in the federal government to review some of their permitting processes under the Clean Water Act and some of the other acts we've referenced. But it essentially bypasses the normal procedures for permitting projects that would apply. And each of the statutes is implicated and administered a little bit differently. So there's not a simple answer to your question, John. But as director was saying, each of those acts provides for specific permitting requirements that projects have to meet, the parties that are participating in those projects have to comply with. All of those provisions are entitled to or intended to protect the natural environment from the danger that might be posed by moving too quickly and not reviewing thoroughly a host of issues. And so essentially the president has attempted to bypass those normal procedures that are intended to keep us safe. But because each of those acts has a number of different provisions, it's hard to specify each of the various things.
Okay, I'll ask this generic way. Is there a danger of hearings or reviews or procedures being eliminated or shortcutted under that executive order?
Absolutely shortcutted. I mean, it doesn't eliminate the Clean Water Act, but it simply bypasses some of the protections, for example, that are within the act.
Washington State, a lot of your lawsuits have been joined with other states.
No, 14 other states. Yeah, but filed here in Washington. But it's filed here in Washington.
Talk about some of the specific projects that maybe they're already in process, so you kind of are looking at those projects that you expect to possibly move along more quickly and to have corners cut on them.
I don't know if the director has any information, but if not, we can provide it later today.
Sort of the worst case scenario that the Trump administration plan goes through as they're proposing.
Communities are less healthy and waters are polluted, and our lands that we protect through all these various statutes are more dangerous. I mean, that is the basis for these acts to exist in the first place, is to provide safety precautions for the public. So you have some assurance that when you go out into your natural environment, you're not going to be sickened by other projects that have been built in the area or that are impacting the area. That is why we have these protections.
Are you seeking a temporary?
No, not immediately. We'll file further action after the complaint today.
Part of a broader strategy to stop looking for those orders in the last few days.
To stop looking for them?
Yeah, that's
Well, no, every single executive action is different. And so we look very carefully at the specifics of the executive action and the harm that is potentially imposed by those actions. So some of those executive orders have immediate harm that we have to go for immediate relief. Some we can move at a more normal course of business. Unlike the president, we don't simply call things an emergency when they're not an emergency. And so we are very thoughtful in making sure that we use our legal tools according to the standards that are set forth. We have a couple things online, I think, Kurt.
Yes, can you hear us?
No. Happy to follow up, Jim. John?
That's question for the chairman. Is there treaty implications in this? I can't remember how many tribes there are, but Washington, but every one of you has a separate treaty with the United States government. And I'll say the really obvious one, you're entitled to 50% of the fish, the normal fishing grounds and have hunting ground protections and so on. Does this executive order throw a real monkey wrench into the treaties?
Good question. Not for us, but generally, yes, it does for most tribes. The Kalas tribe is unfortunate in that there was an executive order issued in 1862 by President Lincoln that opened our lands to settlement without a treaty. And so those are unceded lands in Southwest Washington, nearly 3,000 square miles of Southwest Washington. And so we work proactively with the agencies and the permitting agencies as well to restore the resources. So one day we will have access to our own first foods and traditional uses of the land.
Okay, again, on the fact that with the feds, I know the tribes are separate from the state government. You're your own sovereign government. And I know you cannot speak for any tribe other than your own. But is there a danger to the feds, the tribe saying, U.S. government, you're violating our treaties and we're going to sue the hell out of you?
Well, there will be treaty implications, no doubt, on this, but working with the new administration, I see the secretary has experience working with tribes. So we're just beginning the dialogue with the federal administration. And my hope is that we can enlighten them on some of these issues, better protect the resources, but also help with these permitting conundrums that are created. And the net result for us is that we get 2 weeks to review and respond to a permit. Those are unfunded mandates that come with it. And some of these are pretty significant permits. Some of them are not. They're just pipelines that might be otherwise take 10 years to plan out and decide now I'm going to do it. So they know what they're going to do well in advance. It's a maintenance function, I think, for the pipelines type projects.
You have another question online?
Yeah. What are the specific Washington?
Well, the complaint is, I think, 62 or 63 pages, and it details a lot of those harms. So I would just refer you to the complaint. Anything further?
Sure.
Last one, John.
If I'm doing my mental count correctly, I think this is 14 or 15 lawsuits.
16.
16, okay. Yeah. And what exactly are you seeking from the lawsuits? Are you seeking elimination of the entire executive order? Are you seeking elimination of parts of it? What's your sought after end game?
Well, not the entire executive order, but the portions of the order that illegally bypass specific statutory requirements for how permits are issued and the review process therein. The executive order contains a lot of directives to cabinet agencies that aren't inherently illegal, but the provisions that bypass existing statutory protections for these our natural environment is what we're seeking relief from. Okay, thank you again for everyone for coming. Appreciate it.
Thank you so much. I'm going to apologize. I have no idea how to spell your last name.
It's IY. Hey.